Hi, everyone. Thank you so much for being here. We really appreciate your audience. My name is Claire Smith. I am a financial advisor with Edward Jones, and this is Ruthanne from Voss. She is our local estate planning attorney. We decided to pair together to bring you this seminar today because, estate planning comes in multiple forms, right? And so I'm going to go over your estate planning when it comes to your finances. And Ruthanne will then take it over and go through your estate planning more on a high-level overview and, how to legally bind your wishes if you were to become incapacitated or pass away. So let's start. So when it comes to your finances, as a financial advisor, it's my job to understand what your goals are. So the way that I work with people is, where am I today? Where should I be? Can I get there? How do I get there? How can I stay on track? So I have a workbook that you guys can just kind of use for your records. Go through it if you would like to as we go through the slides, but we won't be, really going through too much of the questions in there, but it'll also give you access to writing down questions if you'd like as well. So that's kind of just a general overview as to how I work with people. And oftentimes estate planning is a big thing that comes into our finances, right? And, when we build portfolios, so when you build your finances, you really want to focus on 3 different areas. So planning for the expected is number 1. And it's kind of what you would expect, right? So planning for the expected is understanding your current situation. What are my goals for my accounts, right? I mean, we just want to discuss your assets, your debts, your income, and your spending goals, that type of thing. Outlining your key priorities and objectives for your account. So maybe you want to leave money to your heirs, but maybe you want to spend it all. You work hard for your money. A lot of people want to just, enjoy it. And also balancing potentially competing goals, right? So maybe we want to leave a little bit of money for our heirs, but maybe we want to also live a very comfortable retirement as well. So how do we balance that? And then number 2 is preparing for the unexpected. So we have our what's expected. Now, what happens if we have something unexpected that happens? Rule changes in tax law, life events. So changes in your personal situation, your beneficiary's personal situation, births, deaths, divorces, income changings, needs, whatnot, incorrect implementations of strategies. So, for example, maybe you put your ex-husband on as your beneficiary long ago, and something happens and he's still your beneficiary. These things happen. And then number 3, positioning your portfolio for both. So how do we make sure that not only have we planned for the expected, but also the unexpected? We want to determine the asset allocation of your finances first and foremost. So basically what that means is, what pool do we have going towards our different goals, and how are they invested, or how are they earning interest, or what products are they in to make sure that they're aligned with that particular goal. So for example, your 401ks, your retirement assets, is all of that going to be spent? So maybe we want to keep that in an allocation that's a little safer. Maybe not all stock, right? Maybe some bonds in there. Or maybe if we do want to pass on some money, we're going to be putting that into a life insurance product for somebody. And we just know that death benefit is going to be going on to our heirs. And that's what that's for. So there's multiple different products that you can use when it comes to estate planning to make sure that you're getting what you need out of it, and you're also planning the best for your heirs as well. And the best way to go about that is to have a team, honestly. Having a financial advisor, having an estate planning attorney, and also having some form of a tax professional that works for you. For example, I can help you identify and prioritize those financial goals of yours, and then also consider how these goals align with your estate planning needs, right? Then your estate planning attorney comes in and she actually draft specific legal strategies that go towards those goals. And then your CPA determines, well, what are our tax consequences, our tax ramifications that come into play as well. So You know, if I give an IRA, if I pass on an IRA to an individual to my son, as opposed to passing an IRA on to my spouse, what does that do for tax purposes for that individual? Or if you inherit something yourself, what does that do for your particular tax situation? Are you paying taxes on that money that you're inheriting? So that's why it's always good to have a CPA looking over these things as well. So state goals, I mean, honestly, the biggest goal is just that establishing control, right? So control of your physical person as well as your assets. So, you know, what happens if you're unable to make decisions related to your physical person and your assets? Maybe you want to leave a legacy to individuals or charities, but maybe you also want to direct your future medical and financial decisions to somebody that will be making those decisions for you. Oftentimes, it's really a good idea to make sure that you have these conversations with your family. If you do want these decisions to be made by somebody, should you become incapacitated, these conversations are kind of hard to have, but I always encourage people to do it. Even your beneficiaries, telling people, you are my beneficiary. Oftentimes people don't know, and they're not sure what to expect if and when you are to pass. Another question I get a lot as well is about, you know, how do I make sure that the government doesn't receive all of my assets if and when I am to pass? I worked hard for all of that, and I want to make sure that I'm putting everything appropriately into different accounts or different areas to make sure that they're actually going towards my goals, as opposed to if I am on medical assistance someday, it's not all just going to the government. So establishing control. So we're going to go through a few things today. So account registration and beneficiary designation, I'm going to touch on that a little bit, and then I'm going to turn it over to Ruthanne, and she's going to go through what's a will, what's a trust, important tax information kind of in there a little bit, and then I'll come back in and talk a little bit about life insurance and transfer on death. Okay, so account registration and beneficiary designations. So what this refers to is, I mean, how many people have bank accounts and retirement accounts and cars and boats and pensions and anything like that? I mean, this is what that refers to. Do you know where the paperwork is for all of these things? And have you registered a beneficiary for all of these things? Especially, you know, especially the things that are going to be something that we would really like to pass on. So it's important to make sure that these accounts are registered correctly, basically. I mean, having a beneficiary on your investments, your bank accounts, retirement accounts, insurance policies, pensions, property, that will directly, these will directly go to that individual whom you have on there, or individuals. And just, you know, the simple task of creating that beneficiary on there. Oftentimes, especially in my world, with investment accounts and with retirement accounts, beneficiaries are, you know, they trump your will, they trump your trust. If there is a beneficiary on your IRA, but it says something different in your will, whomever it is on that, on the IRA that you own, that's who it is going to. It trumps them. So, you know, understanding that, kind of the rules behind that as well. And I'm sure Ruthanne will touch on that, so. And then, you know, again, just wanting to make sure that the information is accurate. So life insurance policies and annuities, retirement accounts, other investments and banking accounts. I kind of touched on this earlier, but oftentimes we maybe think that we have somebody on there, or we put somebody on there long ago and maybe they aren't the accurate person to have on there anymore. So every once in a while, just make a point of going through your different statements, your different accounts, just check these things because it's important and it's good to do. Okay, so I'm gonna pass it on over to Ruthanne here, and she'll chat with you a little bit about some of the legal aspects.
I need to do the fun stuff. I apologize, I have a little tickle because I have allergies. I don't have a cold, so I'm gonna hold my hot water and hope that I don't go coughing, but it's just allergies. So just a little overview. Again, I'm Ruthanne Hedstrom Voss, and I practice in town at Mathison and Voss. The Mathison is retired, but I kept her name on the firm for now because try to say Voss Law Office and you really can't. So it's Mathison and Voss for now. It'll continue for a while. And thank you, Claire, for including me today. It's a pleasure to work with you. And Claire's exactly right in terms of the term approach to estate planning. It is often the team of your financial planner, if you have one, and, or maybe it's your bank or your credit union, and anybody that does your taxes or a tax advisor that you might have, and then your estate planner. It's kind of a three-legged stool. So I completely second that, that approach. Also today, I'm not giving specific legal advice. This is general information. So everybody's estate plan is specific to them. So I'm just going to be giving like more of an educational overview of what these pieces are. So, and those are the types of questions I will answer as well. So what is a will? We may know this. It's a legal document that governs the distribution of assets in your name. And it determines who gets what assets when you die. You can specify who gets what, or just a general split evenly among my kids. You can give money to charities, your favorite organizations. You also name in your will who is it that's going to administer your estate, and we'll get to that in a minute. These slides call it executor, but in Minnesota, these are kind of nationally based slides from Edward Jones. It's actually called personal representative in Minnesota, so it's kind of an interchangeable, but when I say personal representative, I'll mean executor. So what happens when you don't have a will when you die? Who remembers the Prince estate? Prince, I know, it was astounding to me that Prince did not have any estate planning done. I think he procrastinated perhaps. I mean, he was an astute businessman in so many ways, but he didn't have an estate plan done. So the estate fills one in for you. So if you have a will or you don't have a will when you die, unless you have a trust or some other mechanisms, it will go through a court process, a probate process. And there's a little bit of a misnomer out there in the world that if you have a will, you don't go through probate, but you do. The court then verifies that the will is validly executed, it's been witnessed, it hasn't been revoked, it's the current will, all of that. And what kind of assets go through probate? It would be a probate asset, the way I like to define it is an orphan asset. If you own a house with someone else's joint tenants, that's not a probate asset because it has somewhere to go, right? It has a joint owner. If you have a beneficiary designation, as Claire was mentioning, on an asset, it goes to X or X and Y and Z. That's not a probate asset. It has a place to go. What happens if you own a house in your name alone, doesn't have a transfer on death beneficiary? Now only a deceased person owns that asset, whether it be real estate, a bank account, or whatever. Nobody has the authority to go get that asset, to go claim that asset. Even if you have a will that says, my son Tommy is my personal representative, Tommy, without the court's permission, can't go to Donna at the bank and say, oh, look, I've got the will. I want to transfer that account to myself. No, some legal paperwork is required because you can imagine the chaos that people would print out wills and everyone would go collect those assets, perhaps. So that's what a probate asset is. Think of it as an orphan asset that doesn't have either a joint owner or it doesn't have a beneficiary. So that's kind of what we're talking about. We're talking about probate, and when we get to trusts, how those avoid probate. But we're thinking of those orphan assets. If you don't have a will, the state fills in the will for you like they did in the Prince estate that I just referred to. And it follows a formula. And you don't get to pick. This is where the control piece comes in too. You don't get to pick what the distribution is. It goes to your spouse if you're married. There are some stipulations about how long you've been married, but I'm not going to go into all that. But spouse generally, if you don't have a spouse, it goes to your children in equal shares. If any children are deceased, it would go to their children. So it goes down the stem first, over to spouse, down the stem with children. Think of Prince now. He didn't have a spouse, he didn't have children. The next place it goes is up to your parents. He didn't have any living parents, but that's a really weird result that people don't consider sometimes is if your parent might be 98 and living in the nursing home and all of a sudden they're going to inherit a whole bunch of money, it's not really a result that people want. And then if your parents aren't living, then it goes to siblings, whether they're step siblings or full siblings. And that's what happened with Prince. Now, he didn't even have a relationship with some of those siblings, right? But because he hadn't done any planning, they all got an equal share. Were they all happy with that? No, they went to court to fight over how many billions they got or millions or whatever. So full employment for lawyers there. But I wasn't involved, or probably wouldn't be here today. But yeah, so that, it can be chaotic if you don't have some sort of an estate plan or beneficiary designation or whatever, because any of those orphan assets are you want control of how your assets pass. And so that's kind of, again, the overarching purpose for estate planning. Okay, role of, what is it except for, not executor, it's personal representative. Oh, everybody's listening. Okay, give everybody another cookie. That was good. So what is their role? Because, picking this person, you want to be sure that they're up to the task. And I always recommend that you ask them first. You don't want this sprung on you necessarily. Has anybody had this role sprung on them? Like, oh, I didn't know. Yeah, Deborah? It's like, yep. Yeah, so sometimes we know ahead of time, sometimes not. And it's a big job, right? It can be a big or a little job, but you have to have certain skills are helpful. Because the things that you do besides this list here, you have to find the most recent will. You exactly have to collect all the assets of the estate. That means filing a lot of paperwork perhaps and going from bank to credit union to financial institution. It could be IRAs or life insurance. You have to find a beneficiary claim form online. And I have found that bigger banks and life insurance companies, et cetera, don't necessarily love to give up the cash that quick. So they don't make it easy. They don't make it that much harder maybe, but I've just found like some places it's easy. Sometimes you just have to be persistent. So somebody has to have the skills to follow things through, keep track of expenses, be able to, add a column of figures. This personal representative, the process doesn't all happen at once. You file a petition with the court, et cetera, et cetera. It takes at least 6 months and it can take quite a long time, depending on if you have real estate to sell and if it sells. We know the market up here, if you get a house for sale in December, it's probably not going to sell till spring, things like that. So there are things that can delay the process. So then a judge determines whether the will is valid. So you found the most recent will, you deliver it to the probate court along with your petition to open a probate. And is it properly executed? In Minnesota, it has to be signed and dated and witnessed by 2 witnesses. Now, the person has to have legal capacity in order to create the will, right? If they don't know who they are or aren't oriented to time and place and don't know who the objects of their bounty are, what's that? Your kids, who would be the natural recipients of your estate, then you're not able to draft a will. So don't wait. I've had a couple where I was in the hospital having signature things. So don't wait that long. But you do have to do this before you become incapacitated. So they're looking, was it properly executed based on those things that I just mentioned? Had it been revoked? You can always change your will. You can always revoke your will. So even if you find a will, it might be, oh, this one's from 1992. I found the will. Well, let's look. That's quite some time ago. Might there be a more recent will? So that's what the judge is looking at, and that's part of the personal representative's job. And then the judge signs an order granting power to the personal representative. And that's what that personal representative takes to the financial institutions to prove that they now do have authority to collect those assets and distribute them per the terms of that trust or the will document. Okay, there are a couple documents that are really important during lifetime. They don't have anything to do with distributing your estate at your death. And it's a financial power of attorney. And I would combine these two, healthcare power of attorney and living will. In Minnesota, we call that a healthcare directive. So I don't see that as two documents. It's one. And so the financial, and they don't overlap. So the durable power of attorney for finances is naming someone to sign your name for you for financial accounts if you're unable to. So you don't actually have to be incapacitated. These are used when people are deployed, let's say, in the service or traveling internationally, or maybe in the Peace Corps or something. You don't have to prove that that person is incapacitated, but that's generally the purpose for estate planning purposes, is you name someone to be able to sign your name for you. They would present that document at the financial institution or whomever they're trying to act on, the, where the account is that they're acting on behalf of the principal for. Now, this document ends at death, so it only protects your decision-making during your lifetime. You're really saying, who can act for me while I'm living if I'm unable to for myself? And you can have a named person, and you can have a successor. You can have kind of cascading people. You can have two people as co-attorneys in fact, it's called. So again, that role often is the same person that you've named as personal representative because it's someone you trust. It's someone that's going to help you during lifetime if necessary and after death. But it can be different. It doesn't have to be the same person. And then the healthcare directive, now that only covers healthcare decisions, and only if you can't, unless you directly say, yes, I want this person to participate in my healthcare decision-making. But those two are separate things. And that's important too. You have to have legal capacity to obviously execute either of these. The healthcare directive, I know the clinic has, I think it's Honoring Choices. They will give out that one, and Care Partners has that as well. We have a 2-page form that really is just kind of, very direct. It names someone or a number of people that can, in succession, who can make healthcare decisions for you. They have to speak as if you were speaking, so they can't substitute their own decision-making. They have to speak on your behalf. And really what you're telling them you do and don't want if you are unable to make your healthcare decision. That's usually a end of life kind of directive of, whatever you want. Usually it's don't keep me alive by artificial measures, but keep me comfortable, things like that. So, but you have control over what that paragraph says or what that information says. I know we said we'd wait questions till the end, but did somebody have a burning question on that before we move on? I think I saw, no, never mind. Okay, we'll keep going. Just hold your, we'll answer questions at the end. Now we're going to move on to what's a trust. We talked about wills and powers of attorney and healthcare directives. A trust is also in the suite of estate planning documents, and it's one of the choices. And trust is, I'll read the definition, but then I'll tell you what my definition is, okay? A legal arrangement in which an individual gives control of property to a person or institution who is a trustee for the benefit of the beneficiaries. Now, when you create a trust, I'm a visual person, so that doesn't say a lot to me. I think of it as a purse. Who's heard me give that analogy? Probably some people in this room. It's like a purse that you put certain assets in it. You put those assets, remember we talked about those orphan assets that might be just left in your name alone at your death? We put those assets, we title those assets into a trust. This is one type of trust, a revocable trust. There's many flavors of trusts. I'm talking about revocable trusts today. So it's like a will substitute. You put your assets, you retitle those assets in the trust so that you're the trustee during your lifetime, but if you become incapacitated or at your death, that purse just gets transferred to your successor trustee. That successor trustee has the same type of role as that personal representative. They distribute your estate per your instructions, all of those kinds of things. But the beauty of a trust is you don't have to go through a court probate process. It's like magic. No, trusts are well established in law. We brought it over from England. There have been trusts for hundreds of years. It's very self-settled law, very well recognized. And, but if you think of it as just a way to not have the court have to, qualify your person that's going to distribute things, right in your trust contract, your document, it says who is your successor trustee, and they have that authority. So what can a trust do? Lots of things. As I said, there's many flavors of trusts. If you have a child with special needs, often, you want control of what happens after you pass. How is that money going to be managed? Who's going to be in charge of distributing what I have been distributing myself for that child, adult or minor, their care? How do we manage their finances and make sure that things don't go off the wheels when I pass? So it might be a supplemental needs trust, something like that. You can restrict inheritances. Sometimes there's a trust that's part of a will. Again, this isn't a law school class, but I'll just tell you, you can have a testamentary trust. And many people kind of start out with this kind of a will. You're going on a trip with or without your child, and you have young children, and you're like, I need to do a will before we go. What happens if something happens to us? So that starter will might have guardianship provisions. Who takes care of my child or children if I can't? And what happens with their money? It goes into a trust. And at what ages do they get that money outright? You can spend that money for their care until they're, is it 18, 21, 30, 35, 40? Do you have a child with addiction issues? You don't have to you don't have to give them their money all at once. Maybe you want someone to manage their money for them until they're 70. I mean, who knows? It's not a one size fits all. It's, you tell your estate planner what your goals are, what your concerns are, what your family structure is like, and we help you tailor what it is that fits you. So you can restrict inheritances. And there are some tax benefits. We'll get into that in a little bit. If you are exposed to estate tax in Minnesota, if your estate is under 3 million right now in the year of your death, you don't have to pay any estate taxes. So that's a big relief to most of us. And federally, it's 12.9 million. So again, not a lot of federal estate tax exposure, but those numbers can change. So we always look to estate tax benefits there. And again, a trust can avoid probate if you have those orphan assets appropriately titled in a trust. Let's talk about the role of a trustee, because it's very similar to a personal representative. But the trustee, now remember that during your lifetime, you're likely the trustee of your own trust. So this first box, this establish and implement an investment strategy for the trust assets, it's just as if you don't have a trust. That's what you do with your own assets. So you still have complete control of those assets in a revocable trust. But it's also, if you were incapacitated, the trustee also does that for you. So it is similar to the role of a personal representative. You just name a successor trustee, which would be like the personal representative. I'm going to kind of keep moving along here. Now I'm run out of time. So similar considerations when you're naming a trustee, or really I want to say a successor trustee, is similar to that of the criteria for picking a personal representative. Do they have experience in managing financial affairs? Are they fair and unbiased? Do they have time to devote to doing this? And are they good record keepers? I had just a quick story. I had a client who came in, and this wasn't in Cook County, so don't try to think of who this might be. She came in and she said, well, I suppose my son, I'll fill in the blank, I can't remember his name, should be the trustee. And I'm like, oh, I sense some hesitation. I'm like, this isn't like quite feeling right. And she's like, well, he's in prison right now. And then I said, maybe not. And she said, well, he's the oldest and he would be upset if he weren't named. And I'm like, no, this isn't a keeping people happy role. This is someone that has to do some work and be financially responsible, at least, right? Not that he can't be financially responsible and in prison, but I was just kind of making that leap for her, like maybe there's somebody else in your, orbit that might be a better person. It's not a position of honor, it can be, but don't worry about stepping on some toes if you think someone is gonna be upset if they don't really have the skills. But that said, you can name co-trustees. So maybe people have complementary skills. Maybe you have a couple of kids, one is really great with details, and the other one is really, but maybe not as great interpersonal skills, but one has those skills. You can name people as co-trustees. They could work together. Maybe nobody has the whole skill set, but together they do. Or you can name a financial institution that has trust services, a professional trustee as a trustee. So as you can see, lots of flavors, lots of options. And so professional trustees, we don't have any in Cook County currently, but there are some Duluth options. So it's like a bank or a financial institution that would take care of distributing your trust at your death or keeping it going for you if you become incapacitated. And there are some questions to ask a professional trustee. What do they charge? How do they communicate? Do you have a good feeling when you meet with them and interview them that you have like-minded values and, are they going to be similar to your goals in terms of how they would manage your assets? Huh? Oh, yes, Edward Jones does do trust services. I'm sorry, yes, they do. No banks anyway, yes, but true. So we've already sort of covered revocable living trust. It's created while you're living. It's a living trust. It's not done through your will. It's not created after your death. And it's like that purse. That's the purse analogy that I'm talking about, is a revocable living trust. You title probate what would otherwise be probate assets in that trust. And it's a will substitute. It still says what happens to your assets when you die. It can't be changed after your death, so your trustee doesn't have that role. They can't say, I'd like a different distribution. No, you can't change it anymore after you die, obviously, and nobody else can either. And this is kind of the most common trust, I would say, because it's a will substitute. It doesn't need to have special needs provisions or tax provisions, but it can. And it's private, it doesn't go through court, so that is a big plus, I think, for lots of people. It's a little bit more, here are the things that it says, the benefits. So I think we've covered all of that. A testamentary trust, we talked about this a little bit. That's that kind of trust that is created through your will. It does go through probate because it's through the will. The will has to be validated, all the things that we said about wills. But then a trust is set up out of the assets or some or all of the assets in that trust to provide for minor children for a period of time, or maybe to hold a cabin in the family. You can have a sub little cabin trust to keep that property funded for X amount of time for your kids until maybe they've got the financial wherewithal to take it over. As I said, it's common for families with young children, or if you just don't want to create a trust now and just want one created at your death, I said to hold recreational property or something, that's an option. Important tax information. I think I'm going to turn it back over to Claire because this kind of goes into the weeds, and I think just for purposes of, it's in your workbook, you can ask me questions afterwards, but I think I'm going to watch the time. I think I'm done, and turn it back over to Claire so we have time for questions at the end. Thank you.
Okay, so what I'm going to skip us over to life insurance quick. And the same with me, just in the interest of time, I'll breeze through this a bit. But I do know that life insurance is sometimes a little complicated. So I wanted to touch on it for you guys. So oftentimes people use life insurance as a form of planning when it comes time to as to your debt. So, I mean, your probate costs, your administrative costs, your attorney's fees, your burial costs, you know, anything that's in that death benefit. Oftentimes people use that to give to their family, say, hey, pay for these expenses that may come when I pass. So, you know, replaces your income sometimes for dependents. So, you know, if you're still earning money, possibly you want to make sure that they're receiving a certain amount of income for the year, for 5 years, for example, to make sure that they can keep going, pay the mortgage, all of that. Maybe offset expenses such as estate tax. So that was what I was talking about, but provides immediate source of funds for beneficiaries as well. You know, apart from these two important things, sometimes just a little extra for people as well. However much you would like to have, that is, you know, for your heirs at the end of the day. And then there's term versus permanent insurance. So, you know, when you are signing up for life insurance, that's always a question. Do we want this to be a permanent policy? It follows you for your whole life. Or do you want it just to follow you for a certain amount of time, certain period? So term protects survivors against financial hardship. Death benefits to heirs are free from federal income tax. That's always a really nice piece to life insurance, that your heirs are not going to take that as income. But term just means that, you know, we're just offering 15 to 20 years of protection. We're not trying to, if we were to die after 30 years, we would no longer have it. It would only protect us for the amount of time that we agree upon. And usually our cost fluctuates with that as well. It's definitely a lower cost than permanent life insurance. But, you know, the longer term you get, the more expensive as well. So, and then permanent, just like I mentioned, there we go, is your entire lifetime of coverage. So the sooner the better as far as getting this, because that's where your premium cost is determined. It usually has a lot to do with your age and your health. So oftentimes you have to submit health records to insure these insurance companies that they basically take a bet on you in some ways. You know, they bet that you're going to live, or they bet that you're going to pass sooner rather than later. I mean, it's a little harsh, but that is kind of how it goes with these. And loans are generally tax-free. You can take loans off of these policies. That's a really nice benefit along with that cash value. So as you pay premiums into these permanent life insurance policies, as opposed to term life insurance policies, these premiums, they actually build into a cash value for yourself. So you're not just paying it in and never seeing it again. That cash value builds, and oftentimes it's invested within that insurance policy as well. So that continues to grow, and you can take from that whenever you'd like to. And oftentimes there are loans against the death benefit itself. And you can go, you know, even deeper with having riders on permanent life insurance policies for long-term care, for example. I do a lot of that as far as, you know, if you end up needing long-term care, being able to borrow off of a death benefit of your life insurance policy to put towards your healthcare expenses during that time, so that you're not drawing from your 401k and you're not drawing from your pension and trying to pay these health insurance costs. So there are lots of different benefits in terms of riders as far as these permanent plans go. So oftentimes it's really good to look into these, like I said earlier, rather than later, especially if your mom and your mom's mom and everybody else has gone into some type of long-term care at some point. That's always a nice thing to be able to rely on. Or if we have something that's unexpected, back to that, we want to make sure that we have a pool there that's specific for something that might cause us to be incapacitated just for a short period of time, not as opposed to towards end of life. And transfer on death, this is the last thing that I'll go through, and I'll just breeze through it. Transfer on death is very similar to a beneficiary designation. So transfer on death is the term that you're going to see if you have brokerage accounts as opposed to IRAs. And the reason that we say transfer on death is just because it avoids probate. So we're going to have a beneficiary or a person that we're transferring on death our assets to. However, with brokerage accounts, it's a bit easier because everything stays basically the same. There aren't as many rules on these accounts as there are retirement accounts. When a retirement account gets passed on, that's called a beneficiary or beneficiaries, because those assets within those accounts, the rules are different per individual that might receive them. So if you're passing it on to a spouse, that spouse might be able to take that IRA and turn it into their own, as opposed to if you're passing it on to your siblings or your son or your daughter, the rules are going to be different there. They actually have to, with traditional IRAs and 401ks, anything that's pre-tax, they have to take all of that money out of that account, that beneficiary that they had on there, within 10 years. So it's not just a pass on and you get to keep it and you get to, use it for yourself when you retire. No, the government now, and this is a new rule, about 2 years old, you have to take all of those assets out within 10 years. So if you pass on, I'm going to do a high number, but $1 million of extra income to an individual over 10 years is a bit. That puts you up in a tax bracket. So you have to think about that a little bit. That's also why we work with Roth IRAs, for example. Roth IRAs don't have those rules. You do have to take money out, but you don't get taxed on it. So it's kind of one of those things. Those required minimum distributions don't apply to Roths. I'm sorry. You have to have somebody to pass it on to, but they don't have to take any of the money out, as opposed to a traditional IRA. So, but a transfer on death, that's what you will see on a brokerage account. And a brokerage account it's not an IRA. It's just a stock account that you might have, or a bank account, or anything else that might have assets in it that aren't specific to retirement, that has IRA or 401k listed on it, for example. But you guys can ask questions on that if you have them. I'm sure it's a little complicated, but hopefully I did okay. So yeah, now we are ready to ask and answer some questions for you guys. Would anybody like to start? Does anybody have any, just like Ruthanne said, anything burning? Ann?
So did you say that you can have co-personal representatives in a will?
Yep, you may.
Same with the trust.
Yeah, you can have co-successor trustees, and you can have a series, you can have co-successors, and if one can't, does the other one get to act alone, or are you gonna name someone to step up and be co-trustee with that remaining co-trustee? It's all up to you. So you have a lot of choices. You could have an individual with a professional trustee, so with a bank or a trust company. You can have an individual. Sometimes I recommend that, because then you've got the warm fuzzy human that's dealing with the family, but they're backed up by the financial institution that gets the records and holds the money and so it's kind of both and. So a lot of different choices.
So is it possible to have a trust with a executor, say a family member, and a co-executor, Kurt Smith and Edward Jones?
I don't know that Claire does trust work. I mean,
You couldn't have me
Edward Jones
specifically,
could.
but you
You
would.
can't do Edward Jones as far as.
You can do Edward Jones, but it would be somebody that would be assigned to you from our trust department. I would love to do that, but
Yeah, we have.
more schooling to get there.
And is that available in Cook County?
It is, yeah, through Edward Jones. And just like Ruthanne mentioned as well, professional trust services, they all have their own different costs and rules and whatnot. So you always want to look into it and compare and contrast whatnot. But yep, those professional services, they normally have some type of a cost on them. So sometimes it's best to look through your personal network first, just to make sure there's not somebody that will do it or is appropriate at the end of the day.
So this transfer on death, this is just something you need to sign on and make sure that you have that established with
Absolutely.
your bank accounts,
Right.
brokerage accounts.
Unless you have a trust.
Yeah,
Yeah.
there you go.
Again, not to make this a law school class or go too deep in the weeds, but a trust is a type of payable on death designation. So again, what do we put in that trust purse? We might put a brokerage account in there, not IRAs, because IRAs and life insurance always go by beneficiaries. There would be a tax consequence to moving an IRA from individually owned into a trust. That would be a taxable event. We don't want to do that. But brokerage, real estate, bank accounts, things like that, can have beneficiary designations or payable on death designations, I guess I should say, or transfer on death beneficiaries, but those types of things can also go through a trust, so that the trust then says 20% here and 10% here and $10,000 to care partners which you can't always do with a beneficiary designation or transfer on death designation because, you know, putting charities with individuals and sometimes it's hard to get all those things fine tuned. So either or, but it's kind of the same concept. But yes, I'm thoroughly confused, everybody, now I realize.
Where do you set up a trust or?
Yeah, I mean, it's through an estate planning attorney, I do that, and I would say probably 80% of my clients, over the retirement age are in some sort of a trust plan because of the simplicity. A lot of clients come to me and say, it's funny, that's not funny, I shouldn't say it, you use the word funny, but it's common where, oh, I just had, you know, a loved one die and it was a mess and I'm not doing that to my kids. It was, you know, the probate took 2 years, we couldn't find any of the paperwork, it was just a mess. Other people come in and say, oh, my parents had everything in order, they had a trust, it was so easy, the court wasn't involved, I want to make that easy for my family. So that can be one of the reasons to do a trust, and I would say, you know, a high percentage of my clients do trust. There's kind of this misnomer that you have to have $1 zillion to have a trust, and there are reasons. If you have $1 zillion, yes, you should be in some sort of a complicated trust plan, but I don't have clients with $1 zillion, you know, but they want to avoid probate. They don't want their will published as part of the public record. They don't want a probate hearing. They don't want things published in the paper and, you know, arouse the curiosity of people. So, and they want it easier for their heirs. So that's how you establish a trust, is with an estate planning attorney that will, you know, tailor the plan to what you tell them your needs and goals are, and your family structure and your assets and all that kind of stuff.
So is the cost to establish a trust, is it a flat fee or is it based on your assets or?
No, it's usually a range, based on the complexity that is, you know, seen at the time that you have that discussion. At least my practice is I'll give you a written fee estimate at the end of our first meeting if I have the information that I need to do that. And then I know the range, depending on how many moving parts that trust is going to have. Lots of flavors of trust at different costs.
So what would you do at that first meeting?
Good question. Okay, the question is, what would I do at that first meeting? Well, I usually send out an estate planning information questionnaire before that first meeting for you to fill out, to think about who you might want to choose for some of your fiduciaries, those people that would act for you, under your power of attorney, your healthcare directive, your will or trust, some information about your assets, some information about you, your family, kids' names, dates of birth, any concerns you have. And then at that first meeting, we talk about your goals and what you're trying to accomplish and what your maybe concerns about family members are. Can they inherit? Do we need to make any special provisions for anybody? And then I usually discuss the different options. You can do wills, you can do a trust, you know, if it's appropriate, and then what the estimated cost is.
And how much is that first meeting?
How long?
How much does it cost?
It's all rolled into the fee. It's hard to quote fees because it's not a separate fee for that first meeting.
Oh.
And you'll know at the end of that, at least this is my practice, you'll know at the end of that first meeting, you know, what that is going to be, or, you know, your options and what those cost options are. If you just want to come and meet and greet and kick my tires, you know, and not go into all the specifics, that's one thing, but usually, you know, it kind of morphs into those next steps.
Okay.
Well, assets can be moved out of the trust at any time. There's
Yeah.
no time limit.
That's a good point. That when you put assets in a trust, they're still yours. You're still carrying that purse I'm beating that analogy just to death. You're still carrying that purse. You have if you put your house in the trust to avoid probate, you can sell that house. You're going to exchange that house for cash. That cash is probably going to go back into a trust account, right? sometimes that trust is empty by the time you die, right? Because you've spent it, as you were saying, what are your goals? Do you want to live, do you want to travel the world and not leave much for your kids or whatever? We can't always control that, but whatever our goals are, you have complete access to all those trust assets during your lifetime in those revocable living trusts. Did that answer the question? Yeah.
So there would be a reason to do just a will and not a trust? What's the reasons not to do a trust?
A reason not to do a trust might be, well, one might be, if you want the court involved. Now, what kind of situation would this be? Well, maybe you've got 4 kids that fight like cats and dogs, or 2, or however many. And you don't really want to put any individual as the referee of any process where they might be pecked at by a whole bunch of warring siblings. Let the court do that. Let the court have the forum to keep everybody at a low simmer, right? So that could be one. It could be that wills might be often less cost to set up front than a trust. The probate process has another cost to a will that kind of comes later. But some people say, oh, I just want wills, or if you have young children and you just need a guardianship and you don't want to, you're going to be buying and selling houses probably throughout your lifetime, a will is a starter type of estate plan. So pros and cons of each, I would say. Yeah.
Does it protect your asset from the nursing?
That's a really good question. You just feed me the ones that I meant to cover. Because that trust, you have authority over that money, you can spend it on whatever you want throughout your life. It doesn't shield it from paying for whatever you need later in your life, whether that's a new car or skilled nursing care, right? So that's another seminar, a different day on long-term care planning and avoiding paying for nursing home care. However, there's no golden ticket on that. I'll just give you a preview of that whole seminar, because as we know, especially in Cook County, there's where it's hard to pay for nursing. It's hard to keep everybody, it's hard to pay for nursing care, and it's hard to have a pool of money available for those that really can't pay. So those that really, we have to keep the medical assistance pool of money available for those that need it. So there's no real easy ticket, like give everything to your kids the day before you go in, because there's penalties and stuff. But anyway, going down a different rabbit hole. But no, it doesn't protect it from long-term care.
Ruthanne and I have laughed about that a little bit together, because we get that a lot from people, and it's true. I mean, everybody wants to avoid taxes, and everybody wants to make sure that their money is protected from the government at the end of the day. And we do our best. There are ways sometimes to just do little things here and there, but yeah, just like she said, there just isn't a golden ticket. If we had it, we would give it to you.
And we sympathize, we do sympathize, and there are certain strategies that might minimize that. But I think, yeah, getting that across is important.
When the person dies and you said it becomes irrevocable, then the nursing home or medical people get to take money out of it after you die.
If you have bills that still need to be paid, because the trust or the will say, pay my expenses of last illness, funeral, valid debts, all that type of thing. So yes, anything that you've incurred during lifetime does get paid out before your beneficiaries get their money. If you have credit card debt, secured or unsecured, I guess that's a question, but yeah, they will get paid generally. Yes.
If you decide that you're going to go with a will, in addition to making sure you have the transfer on death, any other pitfalls to avoid, or?
With a will? Yeah, if you want a will and you want to avoid probate, remember those probate assets or those orphans, you want to make sure you have a beneficiary designation on everything.